Time for Sports Legal. FrankWalkerLaw.com. Frank Walker is the man you'll find at the website and in Western PA, and he joins us here every week for a view on the legality of certain issues going on in the sports world these days. Frank, how are you?
Good. How about yourself, Ken?
Pretty good. And for folks that haven't been to your site and heard your stuff here on Trib Live, what should they know about you?
I'm a criminal defense attorney, focusing primarily on criminal defense, a little bit of personal injury, but mostly criminal defense in Pittsburgh and Western Pennsylvania area. Website's FrankWalkerLaw.com. Phone number, you can reach me anytime of the day, 412-532-6805. And I like to help people out. They give me a call. I offer real talk, real experience, and real results.
Has Hines given you a buzz in the last couple of weeks? You're a DUI specialist, you know?
Not yet. I'm still waiting for that call. You know, I think he's in good hands. He has some great attorneys down there in Georgia. I know a lot of attorneys in that area, but I think he's in good hands.
Well, just before we get, I wanted to ask you about Richard, and he's got a lawsuit coming up. Richard Mendenhall, another Steeler, but for Hines, this story hit and then it's kind of disappeared for a while. Is this typical? How long is the normal timeline for DUI cases? Do they drag out for several months?
Yeah, they do. They do, and that's not specifically just with DUIs, but with any case, any criminal case. There's so many parties that you have to take into account. Obviously, the judge, and then you have the prosecutor. And there's any witnesses, including the officers. And typically in the summers, you have officers who go on vacation and they're not available, so they have to postpone it for a while. And then at that time, I'm pretty sure Hines' attorneys are telling him to enroll in some classes, enroll in some treatment, and make sure you're taking proactive steps to take care and cure any issues that the judge may think you have at that point. So when you go back in front of the judge, let's say 2 or 3 months from now, say, hey, in the interim, he has not sitting on his hands, not doing anything, and then just done nothing. He's actually taken a proactive step. He's taken some classes. He's addressed this issue. Even though we won't concede there is an issue, if you believe there is an issue, we've had an evaluation. We've complied with all the recommendations, and we're ready to move forward.
Well, and in a case like that, does it help? I mean, for an average guy or girl who gets a DUI charge, if they are proactive like that, will the judge typically give them a little lenience?
Absolutely. I tell my clients from the beginning, if I believe there's an issue, and it's just coming from a non-scientific, non-alcohol specialist, if I believe there's an issue, I'm going to tell you, go get some treatment, go to some AA classes, and come back with some slips and some verification that you've gone, and that way I can take that in front of the judge and say, look, we understand there's an issue here. He or she has taken proactive steps, and we're ready to move forward, and we actually take that into consideration for accepting responsibility for his or her actions.
On the contrary, have you ever had a case where there's an initial charge, there's this kind of a window here now between the first court case, and there's another charge on top of that, another incident, another event that comes up? That's got to be the most unfortunate scenario, but I'm sure that happens.
Yes. And what happens is when you're arrested the first time, you're given what is called a bond, and that's to ensure that you show up for the next court listing. Right. Now, while you're out on that bond, the general consensus is that you do not violate any other rules. Violate meaning just simply getting arrested. They look at that as a violation. Right. So if you get arrested again during the interim between your initial arrest and your court appearance, they're going to call that a violation. They will, instead of getting the bond for the next time, they'll put what they call a detainer on you. Yeah. So you won't be able to get out the jail. Odds are you won't be able to get out of jail for the second charge because, number one, they look at it, well, we'll give you the benefit of the doubt the first time. You gave you a bond. First offense, okay, everyone's entitled to a mistake. But now while you're out on that bond, you took advantage of it, and you got arrested again. So we're going to detain you, and we need for you to sit until the judge can see you, and you tell the judge why he or she should let you out again.
Interesting. All right, let's hope Hines keeps squeaky clean and gets this all cleared up and is back to work with the rest of his teammates. We're talking with Frank Walker, FrankWalkerLaw.com. And one of his teammates, Richard Mendenhall, of course, had a separate legal issue going on in the sense of he endorsed Champion athletic gear, and in the wake of his Twitter comments, the company dumped him. I needed a legal expert when we were talking about this because I would assume there's a contract of some kind here, Frank, where Champion has would you call it like a personal conduct clause in there that they could dump him at any kind, or does Mendenhall have a right to say, basically, he had an agreement and they're backing out on him?
Well, there are a lot of issues here. First, yes, there should be a contract. I believe there would be a contract in this issue. And they're going to have a clause, whether it be personal conduct or conduct detrimental to the company or their products or any personal conflicts. For example, I believe Michael Vick had an issue where he endorsed 2 nutritional companies. And they said, well, we're competitors, so we don't want you endorsing both. So one of us are going to drop you, and we'll drop you. It's the same thing here. I imagine they have a clause in it, something to that effect. Now, the issue here is whether or not he realized what the language said, and it was actually explained to him by his advisors as to what exactly does this mean. They may say conduct detrimental to the company. Well, what does that mean? Can I not say anything, conduct to another person? Can I say something to my personal opinion? That's the issue. Are my personal opinions conduct detrimental to the team if you don't agree, just because you don't agree with them?
Right.
It's just so vague. It's so vague.
Yeah. I mean, and who determines whether it is or it isn't? Would this go before a judge or a jury or what?
Well, it should go before. Odds are it will be worked out in maybe an arbitration panel, or they also have like a mandatory arbitration clause in their contract saying if there's something would arise where the two of us don't see eye to eye, then we will go mandatory. We'll agree to go to mandatory arbitration. Well, you can opt out, obviously, and fight that and say, okay, we wanted to go before a judge. But the problem is you have these contracts, and that language is so vague. The ones who are drafting the contract, they're telling you, this is what we believe it will be. And if there's ever an issue, we will decide whether or not it's that language is conduct detrimental to the team. So it's patently unfair, in my opinion, because usually the person signing the contract, it's not specific to them as to what conduct would constitute a violation of the contract. Right.
They don't specifically say no mention of Osama bin Laden on your Twitter site.
Exactly. But also, I think in Champion's defense, I think it was bad timing. I mean, granted, everyone's entitled to their opinion. They're entitled to think whatever. Yeah. But I think the time at which it was offered, it was kind of like, whoa, we're all looking at this as, some steps forward for world peace or bringing our troops home or whatever. And then you're coming out of left field with this. It was just bad. It was bad timing, in my opinion. I mean, not talking about the actual substance of the statement.
Yeah.
The timing in which it was offered, it was just. I think that kind of accelerated the press and all the heat around it because of the timing of the incident.
Right. If you're champion, you're pretty convinced somebody sees a billboard with Burchard and the champion logo. They might, see the connect between the two and not pick up that pair of shorts and go a different route when they're at Dick's Sporting Goods or something of the like.
Yeah, I mean, I think that's what they're looking at, maybe a loss of sales or something like that. But you have to realize that the people who would make that association, I mean, I think that if you actually look at the numbers, it would probably be a microcosm of their market. I mean, it would just probably be maybe a few people. But you have to look at it. Is it worth going forward with this? And let's say those few people tell a few people now in this viral world, someone hops on Twitter, I heard what Mendenhall said, he represents Chapman, I'll never do that. Someone retweets it. Next thing you know, it's trending on Twitter. Right. Then it's on Facebook. Then it's all over the place. So you never know.
Frank, always fascinating, man. I love your take on the sports legal side of things. Thanks for joining us, and hope you have a safe week. And, we never root for you to get clients, but if people are in trouble, they can come to you for it, right?
Absolutely. Like I said, the phones ring nonstop. 412-532-6805. People call me, and I bring them in, try to help them out, answer some questions, and help them get them out of a bad situation.
That's what we have you for. Thanks, Frank. Appreciate you doing it.
I appreciate it, Ken. Thanks.
I'm Ken Laird. That's Frank Walker, Sports Legal, every week here on Trib Live Radio.